Hello, and welcome to the program portion of OCJP Subrecipient Training. My name is Jeremiah Morton, and I'm the Assistant Director of Programs with OCJP. The purpose of this training is to introduce agencies to OCJP's rules and requirements as outlined in OCJP's grant manual. The majority of the information presented today is located in that manual, but we recognize that many of you are new to OCJP funding, and we want to highlight the important pieces from each chapter, as well as go into our monitoring and fiscal processes. This morning, you will hear from our program team on the management of our grants from the program side of things. This afternoon, you will hear from OCJP's fiscal team, who will present on various grant-related topics. Historically, this meeting had been done in person, but we moved to a virtual format 4 years ago due to COVID-19. So far, we've gotten a lot of positive feedback from doing it this way, as we have people present from all over the state, and sometimes driving to a central location for grant training is very inconvenient. We're interested to hear what you think, and we'll have a survey available for you to fill out related to this training at its conclusion. Before we begin, I wanted to go over some logistics for today's meeting. We have approximately 100 anticipated attendees. So, first, this session is being recorded. One piece of feedback we have received over the past couple of years is that people wanted us to record the session and provide it for later viewing. As a result, we are recording today's session. Number 2, cameras are turned off. Our staff will have their cameras on while presenting, but otherwise, we're not asking our attendees to be on camera. We have a large number of attendees, and we're hopeful that this will help with any connection issues that you may have. 3, attendees are also muted during the meeting today. We will have participants muted throughout the session so the listening experience will be as clear as possible. 4, questions can go in the chat box. We've got staff members helping me monitor the chat box. We'll respond either as the session continues or answer the questions at the end of each session. 5, timeliness. Our goal is to be timely today. We plan to stick to the agenda and hopefully even finish a bit earlier than anticipated. If we run out of time during the session, we may have to cut out the Q&A portion. Don't worry though, we'll save your questions and answer them at the end of the training. 6, attendance. This training is mandatory for some of the agencies today. We'll be doing a virtual sign-in. At each break, there will be a slide with info for how to sign into the training. You only need to do this once today, even though the slide will appear at each break. Please make sure you sign in to receive credit, as this will also let you get any materials that we send out related to the training. 7, survey. At the close of today's session, we will send out a survey. I encourage you to give us your honest but constructive feedback on our sessions so we can improve for next year. And lastly, the PowerPoint. We will send a copy of the PowerPoint to those who sign in during the breaks later next week. Now, with those ground rules out of the way, we'll begin, and I'll pass things to 2 of our experienced staff members, Program Managers Chantrell Johnson and Nick Nelson. Chantrell and Nick, take it away.
Good morning, everyone, and welcome. Chantrell Johnson and I will be covering this first portion of the training. The Office of Criminal Justice Programs is committed to a safer Tennessee for all of its citizens. OCJP functions as a strategic planning agency that secures, distributes, and manages federal and state grant funds for Tennessee. While collaborating with other public and nonprofit agencies, OCJP utilizes these grant monies to support innovative projects statewide in efforts to reduce criminal activity, provide services for victims of crime, and promote overall enhancement of the criminal justice system in Tennessee. Working together for a safe Tennessee is our vision. Next slide, please. Operational status. OCJP Grants Manual, Chapter 2, Achievement of Operational Status, Sections 3 through 5, Grant Personnel. In the context of grant projects, achieving operational status means the project has been implemented and all necessary steps have been taken to ensure that it can operate as intended. This includes the development of policies and procedures to ensure the project is fully functional and meets all applicable standards and requirements, and hiring staff. Achieving operational status is often a critical milestone in the life cycle of the grant project, as it marks the transition from construction to operation and maintenance. Next slide, please.
All right, good morning. I will go over the 3 key roles when it pertains to grants through OCJP. And each role plays an important part in fulfilling the requirements of the OCJP contract. And these roles are the project director, the financial director, and the authorized official. Next slide, please. So the project director, this is a person that possesses knowledge and experience in the project area with ability in administration and supervision of personnel. This person ensures the project is being implemented as described in the project narrative or scope of services, and assumes responsibility for the direct and subcontracted services. This person confirms all grant requirements are completed and documented within specified deadlines as outlined in the OCJP Grants Manual or email correspondence from OCJP. The project director also shares responsibility with the financial office for seeing that all expenditures are within the approved budget and that all reporting requirements are met. Next slide. The project also assures any subrecipient personnel working within the grant-funded project receives copies of all information distributed from the Office of Criminal Justice Programs. The project director verifies client files are maintained on all individuals receiving direct or subcontracted services under this grant. Also, the project director is also responsible for providing oversight and coordination of the program and fiscal monitoring conducted by OCJP. And please remember that the project director cannot serve as the authorized official or the financial director for the project. Next slide. And the project director ensures a grant file is maintained on each OCJP grant to include the following. You must always have a signed contract and any amendments, certifications and special conditions, email approvals from OCJP, and all reports must be maintained in the grant file. Next slide. Oh, I'm sorry. You can go back to that last slide. The little chart that was at the bottom, this is just something called, that's part of our detailed review guide. So that when we come out to do a monitoring, we will look to make sure that your grant file is maintained. Next slide. And the project director also ensures that the required personnel complete the civil rights compliance training within 90 days of assignment, and also verifies that the Title VI civil rights sign from OCJP is visible to clients in a common area. And this is just an example of the sign here. Next slide. We also verify that the Tennessee Comptroller's public accountability sign is also visible to clients in a common area. So this is something that we will look for when we come out to monitor you. And so this is something the project director is also responsible for having posted. And the dimensions of the sign must be 11 by 17. And here is an example of what this sign looks like.
The fiscal director is responsible for all fiscal matters relating to the grant-funded project. The fiscal director is also in charge of accounting, management of funds, verification of expenditures, and grant financial reports. And the fiscal director must be aware of acceptable accounting practices and possesses the fiscal skills necessary to adhere to the financial requirements of the grant. Next slide, please. The fiscal director also establishes and maintains grant accounting systems and financial records to accurately account for funds awarded, coordinates with project director in preparation of all documents for the OCJP financial fiscal monitoring, and remains knowledgeable with the OCJP grants manual and all responsibilities associated with the fiscal function of the OCJP grants. Next slide, please.
Okay, and now I will go over the responsibility of the authorized official. The authorized official is approved to enter into binding commitments on behalf of the authorizing agency. The authorized official is able to sign any contract between an organization and the state of Tennessee. If a contract is under a state or local government, the authorized official must be mayor, city manager, county executive, district attorney, or state commissioner. If a contract is under a nonprofit organization, the authorized official must be president or chairperson of the board of directors. Next slide. In rare cases, OCJP will accept that an authorized official has delegated signatory authority for the signing of legal binding contracts, special conditions, certifications, and other grant forms. If the board president is anticipated to be absent, then the board president may designate another board officer with permission to sign on behalf of the board president. The designee will then apply his or her initials at the end of the name of the president's in extension signature. This permission must be in writing. It must be within the agency's policies or bylaws, and be approved by the board of directors and documented in the board minutes. The official letter requesting signatory authority should be on agency letterhead with the following information: printed name and title of authorized official, printed name and title of designee, description of what documents will be signed, duration of the designation, signature of authorized official, signature of designee as authorized official. The letter requesting permission supporting board minutes and policies must be submitted to OCJP prior to the designee option being used.
One key thing to remember is that OCJP must be notified via email within 10 days in the event of a change of one of these three key roles: the project director, the financial director, or the authorized official. And that will conclude this segment of the training.
Any questions?
Awesome. Thank you so much, Chantrell and Nick. The only question I see in the chat was related to if we'll be sending out the PowerPoint. And yes, absolutely, we will do that. At each break, we will have a link that will appear on the screen throughout the break where you can sign in. I recognize that the email invite I send out oftentimes gets forwarded to different people. And so in order to get it to the people who are actually present, I'll use that sign-in list, and then I'll push out a copy of the PowerPoint, the training survey, as well as a link to the video next week. Now, not seeing any other questions, I'll turn it over to Chelsea, Catherine, and Kate for the topic of Board of Directors. Take it away.
Okay, good morning. I'm going to talk to you about the Board of Directors and the makeup. The Board of Directors is a governing board of nonprofit organizations. It's the legal contracting entity, and they are responsible for the overall operation of the nonprofit organization. The Board of Directors acts as stewards accountable to the state government, granting their respective charters, the federal government for their tax-exempt status, and to the public. And I want to mention here that the government-led programs that have the advisory boards may also be subject to some of the following requirements that we're going to talk about, but they're not subject to the same regulatory and statutory requirements of a 501c3 governing board. Next slide. Okay, so your board composition, who is on the board, you want a diverse group of people representing diverse backgrounds, experiences, and socioeconomic groups. And you want to think about your community that your organization serves. It's important that if you have a victim service organization, that you think about having a survivor on the makeup of that board. And to kind of give the input and to make the overall organization succeed. What should they know? They should be familiar with the organization's programs and activities and understand the key skills and knowledge, such as nonprofit trusteeship, financial accounting knowledge, personnel management, public relations, organizational planning, fundraising. And this is especially a big one if the leadership of the program is grant funded, then the fundraising responsibility is going to fall on the board for doing that. So you want to make sure that they have that skill set and that those expectations are clear before they choose to serve on the board. I want to note that some boards, like domestic violence agencies, have specifics regarding the composition of their board of directors. So you're going to want to check the statutes on that. And then if you have any questions, reach out to your program manager. Why this is important is the board provides the capacity oversight, formulates the policies, and provides the strategic planning for the organization overall as a whole. And I'm going to turn it over to Catherine, and she's going to talk more about their responsibilities.
Thank you. So the board responsibility, the main functions of your board of directors should be to establish policies, regulations, and bylaws, also to resolve management issues within the organization, select, evaluate, and advise the executive director. And the board of directors is going to be financially liable for the service programs described in the grant contract. The board of directors' responsibility to our office and OCJP would be to ensure that grant requirements are met. The board president or chair is going to serve as the authorizing official that we already just talked about. Policies are in place to prohibit nepotism and conflicts of interest. This is between the board and the agency and also within the agency itself. Board meeting minutes are maintained. The board is expected to accept liability for resolving any question costs resulting from OCJP monitoring, and then review any grievances that the organization may receive. Next slide, please. The board required training. So all board members are required to complete the resource sharing project e-learning course training within 3 months of joining the agency's board as part of their orientation. Organizations who are new to OCJP funding should request that all board members complete the training within the first 3 months of the contract start date. A certification of completion should be signed by each board member and kept in the agency's grant file. The training is located there at the link for the resource sharing project. You can also go into the OCJP Grants Manual Chapter 2, the Achievement of Operational Status, to review any additional information and to also review if there are any exceptions. Sometimes an organization, if they already complete required training that encompasses all of the requirements and the categories within this resource sharing project training, we may be able to count that for their board training. So just reach out to your program manager if you do have questions about that, and you can send your policies to your program manager. Next slide, please. And then additional board responsibility resources. As mentioned, you can go to the OCJP Grants Manual Appendix M for nonprofit organizations and the governing board of directors responsibilities. You can also go to the Tennessee Secretary of State Division of Solicitations and Gaming for additional resources to support your board. And now we'll turn it over to the next segment.
Awesome.
Hi. Oh, sorry. Go ahead.
No, you are fine. I was just going to say great job, Chelsea, Catherine, and Katie. I'm not seeing any new questions in the chat. So Haley, turn it over to you.
Okay, great. So we're going to jump right on into civil rights compliance. All subrecipients must have a written policy that prohibits discrimination in both employment and the delivery of services or benefits based on race, color, national origin, sex, religion, and disability. The policy should also establish a civil rights complaint procedure. All subrecipient agencies must notify their employees, program participants, beneficiaries, and other interested persons of the written policy and complaint procedure. In the event of an allegation or adverse finding of a civil rights discrimination, OCJP subrecipients must notify OCJP by completing the Civil Rights Complaint Notification Form, which can be found in the Grants Manual Appendix P within 45 days. You can find a full list of laws that protect civil rights in federally assisted programs in OCJP Grants Manual, Chapter 22. These laws that may apply to OCJP subrecipients collectively prohibit civil rights discrimination in both employment and delivery of services or benefits. Next slide, please. OCJP requires that all grant project directors and the civil rights compliance officers provide evidence of completion of the civil rights training provided on the OCJP website within 90 days of their start date and then annually. Subrecipient agencies must also train all of their staff members annually by using the training program on OCJP's website or another training program that includes information on civil rights compliance. Project directors are responsible for maintaining documentation showing that staff members completed the required civil rights training annually. Verification of that training must be retained in the personnel files. Next slide, please. All right, this slide is going to be going over limited English proficiency. Each subrecipient agency should have a plan to assist clients with limited English proficiency. LEP clients are individuals who do not speak English as their primary language and have a limited ability to read, speak, write, or understand English. Title VI of the Civil Rights Act of 1964, as well as DOJ program statutes, require subrecipients to take reasonable steps to ensure that LEP persons have meaningful access to their programs and activities. Providing meaningful access will generally involve some combination of oral interpretation services and written translation of vital documents. For information on providing services to LEP persons and for detailed agency-specific guidance on language access services, you can see lep.gov. Next slide, please. And Aaron Morris is going to take over from here, going over conflict of interest and nepotism.
Good morning, everyone. So we're going to begin by discussing a conflict of interest. So OCJP, specifically in the grants manual mentioned here, the pre-award requirement section D, that's what we're going to be discussing. So the first bullet here is personnel and other officials connected with agency-funded programs shall adhere. Advice: no official or employee of an organization shall participate personally through decisions, approval, disapproval, recommendation, the rendering of advice, investigation, or otherwise in any proceeding, application, request for ruling or other determination, contract, award, cooperative agreement, claim, controversy, or other particular matter in which award funds are used, where his or her knowledge, his or her immediate family member, partner, organization other than a public agency in which he or she is serving as an official, director, trustee, partner, or employee, or any person or organization with whom he or she is negotiating or has any arrangement concerning prospective employment, has a financial interest or less than an arm's length transaction. Next slide, please. So use of agency project funds, officials, or employees shall avoid any action that might result in or create the appearance of providing private gain, giving preferential treatment to any person, losing complete independence or impartiality, making an official decision outside official channels, affecting adversely the confidence of the public in the integrity of the government or the program. We have the Tennessee Annotated Code referenced here as well, addressing nepotism. Relative means a parent, foster parent, parent-in-law, child, spouse, brother, foster brother, sister, foster sister, grandparent, grandchild, son-in-law, brother-in-law, daughter-in-law, sister-in-law, or other family member who resides in the same household. All agencies must have a policy regarding conflict of interest that incorporates the above definition of relative as it pertains to nepotism. Thank you.
Awesome. Thank you so much. We do have a couple of questions in the chat. One of the questions was related to the, let's see here. It was related to the comptroller sign that was put up earlier, and how often we come out to look for that sign. So typically that piece, that requirement is involved in our monitoring process. I would say for most programs, you'll be monitored at least one time within the life of your contract. And we typically provide you at least 30 days notice before we come out. And that 30 days notice comes with a request for additional documentation that's necessary for monitoring. I'll also add that it's typically not the situation where we're simply contacting you and saying we'll be there on like June 3rd. It's usually leads up with an informal phone call where we kind of work out a date with you that'll work well for us as well as your organization. And so then we wrap that sign piece into our monitoring. So that's really the time that we're going to check it for compliance. We do have a resource in order to get you a sign, and I will work with our team kind of as the session progresses to provide that information in the chat about what the easiest way is to get a sign. Let's see. There's a question about who has to complete the civil rights training. So the civil rights training really only needs to be complete, our civil rights training rather, really only needs to be completed by 2 individuals. It's going to be the project director and the civil rights coordinator for your organization. When you accepted your contract with us, more than likely you signed a packet of certifications. One of those certifications was to declare who your civil rights coordinator was. And so our expectation is that individual, or really that position, right, because the individual could change, conducts or goes through our training, as well as the project director. The good news is that that training and that test really only takes about 15 minutes. And so it's not a huge hurdle to get through, in our opinion. Let's see if there's any other questions. There's a request for the checklist that we utilize while monitoring. We can absolutely provide that. And a request for the link to the training. We'll get that as well as the session progresses. And our volunteers of the organization required to complete the civil rights training as well. In terms of our monitoring for compliance, we're only checking for the project director and we're checking for that civil rights coordinator. So we are not checking the volunteer files for that training completion. And then I think that covers all of the questions that are currently in the chat. Great questions. Please continue to ask more as they come up. And now I believe we're on client files, grievance procedures, and releases. And so I will turn it over to Logan and Mary Beth.
All right. So for client file documentation, it is imperative that your agency has a way to document the services that you are providing to each client. Depending on your program type, this could look different from agency to agency. Each client served should have a file documenting any and all services received. This is including but not limited to types of case. So this is also called the victimization type. So for example, domestic violence, homicide, and so on. Client eligibility, your agency will want to have some process in place to verify that your clients are eligible. Communication, so this would be letters, copies of letters, notes of conversation, class completion, anything that you've done with the client would need to be within that client file. So for example, if you wrote a letter on behalf of the client, you would want to include that. Referrals, so the criminal injury compensation, shelters, counseling, food bank, any referrals, you would want that to be documented and when you made that referral. Signed release of information. I will be talking about this in a few later slides, but any signed release of information should be maintained in the client file and up to date, and we will talk about that. Safety planning. If your agency completes a safety planning or a safety plan with your clients, you will want to make sure that that is documented in the file as well. You can do this by completing case notes or just putting a copy of that specific form that shows it was completed. And then any activities provided to the client, including dates and details, you want that in the file. It is important to ensure your agency has a documentation process in place. That is easy. You don't want that process to be difficult. Some agencies utilize databases, spreadsheets, or just a Word document for case notes. Whatever method is best for your agency is fine. We do not dictate what your process should be, only that you have a process. If your agency does utilize a database, ensure that that information in the database is correct and can be viewed by your program monitor. You can do this in a variety of ways, like taking screenshots or printing off the information when they come for monitoring. You will just want to keep in mind, if you want to go back a slide, I'm not to that one yet. You will just want to keep in mind that any information viewed by the monitor has been redacted of all personally identifiable information. Now you can go to the next slide. Okay, so what you're seeing here, this is our detailed review guide, which guides us for what we're looking for when we come out to monitor. I know many of us have probably heard the phrase, if it's not documented, then it did not happen, which is why it is important to do all of the case file information that I had previously talked about. So just briefly, we're looking at, has your program been implemented as stated in your scope of services? Are your grant funded activities allowable? If you're like an FJC, shelter, or sexual assault center, you are following the specific standards that apply to your agency type. You can go to the next slide. Thank you. Also, we want to know, do you have an intake procedure that you're using for your program, and what the intake procedure identifies if the clients are eligible or not. This is common for most fund sources. You have a priority area, so you want to check to make sure that that individual falls within that priority area. And then on 2 and 3, we are looking at the clients you're serving are actually eligible, and they are that target population that you identified you would serve. This detailed review guide is given to give you some background when we come out to monitor. This sort of helps you know what areas we focus on when we do monitor. If you want a copy of this detailed review guide, you can email your program manager and they can send it to you. I know a lot of the program managers do send this out when they're coming for a monitoring visit. So it is something that you are welcome to have a copy of. If you want to know what you should be documenting, a great place to look is your scope of services, which includes the types of services your agency stated you would provide. Examples would be the counseling, case management, safety planning, and so on. It also includes a section of your outputs of what types of clients you should be documenting in accordance to the client files. You can go to the next slide, please. So this is an example of a tracking sheet that was provided by one of our victim coordinator programs. As you can see, there is a section for demographic information and special classification that the agency tracks. As a VOCA funded agency, the wording for special classification is directly from the PMT report. Then below you can see the contact section of where it lists specific types of contact that's listed for the agency's scope of services. So this is very customized to one particular agency. For example, you could have referrals, as I previously had stated. You would just want to mark that where it says referral to other services. So like, say someone needs to emergency food box, you would put to the food bank there. Okay, you can go to the next slide. Okay, grievance policy, the procedure. So all OCJP funded agencies provide direct services are required to establish a written grievance process in their policy and procedures and maintain a system through which recipients of services may present grievances about operations of the service program. Domestic violence shelters must follow the guidelines put forth in the Family Violence Shelter Standards. Clients should receive a copy of the grievance procedure, and it should be documented in their client file. And the requirements and simple procedure can be found in the OCJP Grants Manual, Chapter 2, the Achievement of Operational Status. A key takeaway from the grievance procedure is that the clients do need to receive that copy of the procedure, and it does need to be documented in the case file. So similar to other requirements that we have, if you're providing your clients with a packet of information, you could put the grievance policy in there, but you would still want to document either a case note or some form of checklist or something to indicate that you have provided this. You could also do an acknowledgement form. That way you can show that each client has received the grievance policy. Okay, you can go to the next slide. So grievance policies under the family violence rule should include the following: procedures which clearly describe the lines of decision-making for appeals to be submitted in writing within 24 hours of the event, response to an appeal at each level to be within 24 hours and in writing, a copy of the grievance, supportive information, and disposition of the appeal to be made in the individual's file. You can go to the next slide. So grievance policies for other agencies shall include the process for submitting a grievance. This process should not allow a grievance to be submitted to the individual that is the subject of the grievance. A reasonable period for investigation and responding to a grievance. The process for appeal, if the response is furnished by any individual other than the agency's ward or appointing authority. A copy of the grievance and disposition must be maintained in writing in the individual's file. So the difference between this one and the one for the family violence is that 24-hour time frame. So if you do not follow under the family violence rules, then you do not have that 24-hour time frame. The grievance we have for the guidance we have for grievance procedures is more specific based off of your agency type. So hopefully all of you know what type you fall into, but if you have questions, you can get with your program manager and look into which one would be more appropriate for your agency. You can go to the next slide. So this is an example of the grievance procedure and can be found on our website, but keep in mind this is an example that is more restrictive version that mentions the 24-hour time frame and that is not a requirement for all agencies. It's only the requirement that fall under the family violence rule. However, this example still provides a good framework for what the policy can look like. It also hits all of the required language for agencies who follow under that family violence rule. If you do need an example, reach out to your program manager. I know myself, I have a few examples. I'm sure others do. That way we can help you make sure that it includes all of that verbiage. Okay, you can go to the next slide. Release of information. So release of information forms are very important if you're providing direct services to clients. Subrecipients shall not disclose, reveal, or release any personally identifying information or individual information collected in connection with services requested, utilized, or denied through the subrecipient's programs, regardless of whether the information has been encoded, encrypted, hashed, or otherwise protective, or disclose, reveal, or release information, individual client information, unless it is a release of information should be used. So the release should be written in reasonably time-limited consent of the person, limited to one specific recipient of information. Personally identifying information is considered their name, address, birth date, social security, so on, as it is any information that would identify who the individual is. Your agency cannot disclose this information to anyone unless you have the written release form. It has been questioned previously if a verbal release would be acceptable, and it is not. You must have a written release. We're going to go over an example, so if you'll go to the next slide, please. Okay, so here is an example of a release of information. We do have this example available on our website as well. So if your agency is already using a release, as long as it includes the items previously discussed, that is fine. Otherwise, you're welcome to pull this from our website and use this for your agency. As you can see from this example, the release is specific to who wants their information, who they want their information to be released to, and what the purpose it is being shared for. You can also see that it is time limited at the bottom. It specifically states when the release will expire on a specific date and time requested. It can be extended. There is a spot at the bottom of this release that allows for you to extend if necessary. That's commonly done. But this is an example of meeting all of our requirements with this specific, it's time limited, it's written. So that's what OCJP is looking for. Can go to the next slide. And this is just a picture of the detailed review guide that we use and why we are talking about releases. Why do you need the policies around release of information? Well, when we come to monitor, we are looking for this requirement of being grant funded with OCJP. Therefore, your agency will want to make sure there's a process in place. As I've previously said multiple times, if you're not sure if your policy meets the requirements or you need to do something with your release policies or your release, you can get with your program manager and they can assist you. Okay, thank you.
Awesome. And we have reached our first break a little bit ahead of schedule. Let me just go through the questions real quick here and kind of share the information with the group that we've answered within the chat. Let's see. There was a question whether or not the civil rights coordinator and the project director can be the same individual. The only forbidden overlap that we have is that the project director, the fiscal director, and the authorized official must be 3 different people. If your organization is structured such that your civil rights coordinator shares a role with one of these individuals, then that is not something prohibited by us. Again, you would have declared your civil rights coordinator when you filled out our certification packet. And so if that position is going to change, I would just make sure you let your program manager know as they're coming out to monitor so they know who specifically they should be looking for certificate wise. Did provide a link to the civil rights form in the chat. It's also linked as Appendix C in our grants manual. We were asked for if we have a version of it that is, I believe, in Spanish. We don't have a link in our manual currently, but we can work on providing you with that resource. What I would ask you to do is to please reach out to your program manager and state that as a need that you have, and we'll be happy to follow up and try to find you the poster in another language. Let's see. This question about expectations for the grant as part of the HR and staff manual. So we should have done a pre-award or risk assessment with your agency unless you're with the county government. When your agency first started receiving funding for us, we would have at that point looked at your fiscal policies and practices to make sure that they were in alignment with our expectations. Related to program policies, most of our policies follow what would be like typical HR procedures. So there's typically not a need to develop grant specific policies. However, like your results may vary depending upon the style of project. I would encourage you to reach out to your program manager. They can provide you with a list of our required policies, the manual sections, and can even go over your policies with you to figure out whether or not they're compliant prior to any monitoring, which will save you kind of the turmoil that could occur around the time of monitoring. There was a question about scheduling the monitoring 30 days out with summer approaching. I would again recommend that you ask your program manager. They already know which agencies are set to be monitored this year. And by and large, it's not a secret, right? We just typically don't let people know that they're going to be monitored 6 or 8 months in advance, because it's been our experience that by the time we get closer to that date that, people have kind of already forgotten about it. I know that you may not necessarily be that type of person. So we do typically reach out to you more informally prior to 30 days in order to work with your agency to set a date. And then based upon finding that date that works for everybody, locking it in and then providing you with the pre-monitoring documentation. If you have a specific concern, though, you can reach out to your program manager. The questions I would ask is, am I currently set to be monitored this year? And if so, when do you anticipate coming out to monitor me? Most of our program managers have developed kind of personalized monitoring plans. So they kind of know throughout the year in which section of the year they'll be going out to different programs. And so if you reach out to them, they'll probably be able to provide you with that information. And then if it's a kind of an area of time that's particularly concerning to you, y'all could go ahead and start working it out if you wanted to. And I'm just scrolling through the questions here real quick. See, there's a question about the program being given permission for the tracking sheet to be shared even as a reference. I'm not 100% sure what that's in reference to. So if there's anyone on the OCJP team who maybe saw that question come in during a specific piece of the presentation and can speak to what's being referenced there, I think that would be helpful. Otherwise, Rachel, if you'll give a little bit more detail about what we were talking about at the time, I'll be happy to respond to that. It's a question about receiving the policy. Does this include digital form that they acknowledge, or are you referring to paper copies they are handed? You know, when we're reviewing documentation, we'll typically either accept a digital version or kind of a handwritten version like for a release of information, because of the way that those are customized. It's been my personal experience that like 90% of the time those are paper forms. But if you have a system where they're maybe doing intake paperwork on a tablet and it's all electronic, that would be fine with us. When we come out and monitor, we're just gonna ask to review the electronic file. I think what a lot of agencies do in practice is they'll print out the electronic files that we sample in order to provide us like hard copies of that documentation to flip through. That way we're not sitting at one of your computers like with access to your system. We will go over monitoring just a little bit later. Actually, it's our last session, so we can kind of expand upon that then. But typically speaking, either hard copy or electronic copies of forms are acceptable to us. And I hope that addresses the question. It's a question about acknowledgement in the file. I'm not sure which specific document that's referencing. You know, sometimes with the intake paperwork, there's kind of a list of brochures that'll be given. One example is if you're a VOCA funded program or a program that does victims compensation, we have a requirement that you provide victims compensation information to grantees. They don't necessarily have to sign a copy that says that they've received that brochure. What we're looking for is something in the grant file that shows, like, it can be a checkbox that these are the 5 items that are given and we've checked that all 5 were given, and that would typically meet our compliance standard. There's a question, do all clients need to fill out a release of information form? No, they don't, because we require rather for our releases of information to be specific and time limited. It would actually be kind of against our guidance to do kind of a blanket release of information at the start of a grant that basically says, for the next 12 months, you can share all of my information with whomever. And so rather than having that blanket release, which typically we wouldn't consider to be compliant, we do look for specific releases for specific situations. So there's not a need kind of at intake to get them to sign any kind of blanket release, but rather as there's a specific need to release information, working with the individual client rather, and doing a specific release for that situation. There's a question about the program managers on the training link not being listed. That's I'll take ownership of that. I don't think that I remembered to update that list. You can pick any individual that you want. What will happen is the program manager won't get an individual email, but that's fine. What I do is I make the list available to them anyway. So just your name and agency information, which the form asks for, we can sort to it and get to it there. And so the most important thing is just make sure that you fill out the form. You can pick any program manager from the list, and it'll be processed, and you'll receive credit. Yep. Another question for Strong Families and OCJP Program Manager. Again, I apologize, that form did not get updated evidently. So if you'll just pick any fund source and any program manager, when it goes through, we'll know to look for your agency, and I'll see if maybe over the break I can add Tennessee Strong Families and maybe some other information, but don't worry about the individual selections. It's more about making sure your name and organization are on that form. And again, I apologize for the confusion related to that form. There's a statement that the firewall is not allowing access to the tiny URL link. I can put the long link in the chat for you, Michelle, and if that doesn't work, we'll figure out another alternative for you to get attendance, and that could just look like emailing your program manager. And then when I dump the list, what they'll do is just manually add you to it, and then you'll get all of the subsequent notifications. But I'll grab the kind of long form title, put it in the chat, and you can try to click on it there, and hopefully that'll go through your firewall, because the tiny URL, yeah, it was made to make the link shorter, but I could see how some like security systems might not like that, because who knows where it links, right? Don't see a certification specifically identifying a civil rights officer. Amanda, that could be program specific. I don't know. I'm trying to think if Tennessee Strong Families has a different requirement. I don't know if anyone from that team is available and can unmute and speak to whether or not that's a required certification for that grant program. I do know that if you receive federal or state funding from my unit, it should have been in your packet. If you want to reach out to your program manager, they can also go through that with you. We'll have copies of your certifications, or should have copies of your certification, and can help you identify the person that was named at that time and then alter it if that's a need. And I think that that's all of the questions. If I've missed anything, please feel free to put it back in the chat. Again, I'm going to get the long form training link and put it in the chat. And if both of those links aren't working for you for whatever reason, just email your program manager and say, like, I'm here, because we'll also have the output for the attendance from this actual meeting. We just won't have the emails and stuff associated with it, but it'll be very easy for us to marry up who was present. Okay. Well, if there is no other questions, we have got a break. I've got 8:55. Let's do 15 minutes would be 9:10. So if everyone will come back at 9:10, and we'll keep this slide up for just a bit longer, and I'll drop the long form link to that in the chat now, and then also when we return. So don't think that you have to sit and wait on it. I'll make sure that it gets dropped in the chat fresh when we all come back at 9:10. See y'all soon. Thank you. Jeff, if you're back, you can go ahead and unshare your screen, and then Robin, if you want to pick it up and move to the break slide, we'll get going here in just a minute. All right, I have 9:10. Welcome back, everyone. I am going to put into the chat right now the direct link to the attendance form. This doesn't use the tiny URL link, and so hopefully systems that are suspicious of redirects like that will let you click on the direct link that goes to Tennessee's FormStack site. I hope everyone enjoyed their break. We will now resume with allowable and unallowable costs featuring Ben and Amy.
Good morning, everyone. So I will start off by discussing allowable costs, and then Ben will take over unallowable costs. If you can go to the next slide. Allowable costs are those cost principles identified in the Federal Uniform Administrative Requirements, cost principles, and audit requirements for federal awards. You can find more information about those in Title II of the CFR 200, specifically Part 225 and Part 230. In addition, costs must be reasonable, allocable, necessary to the project, and comply with the funding statute requirements. For more information on allowable costs, you can refer to Chapter 14 of the OCJP Grants Manual and the specific fund source chapter for your fund source. Allowable costs must be approved in the grant budget. I encourage people to go and refer to their grant budget that's part of their contract. The cost must be consistent with organizational policies and procedures, follow federal fund source guidelines, must be generally accepted or use generally accepted accounting principles, consistent with treatment of similar cost, document methodology. They must be ordinary, necessary for operation, and allowable, reasonable, and allocable. Conferences, meetings, and training activities, meeting rooms, and audiovisual services must be pre-approved by OCJP. Planners are rarely allowable and must be pre-approved. A planner is an individual contracted to plan trainings and conferences. Out-of-state travel for conferences, meetings, training activities is rarely allowable and must be pre-approved. All OCJP funded events that include lodging for 30 or more participants must not exceed the federal per diem rate. If costs do exceed the federal per diem rate, the grantee shall be responsible for the full amount, not just the amount that exceeded the per diem. Occupancy and space, rental cost of privately owned space is allowable. Rent cannot be paid if the building is owned by the grantee or if the grantee has a substantial interest in the building. No cost can be applied for buildings that were originally purchased or constructed with federal funds. Maintenance and operation, the cost of utilities, insurance, security, janitorial, elevator services, upkeep of ground, normal repairs and alterations, and the like are allowable to the extent that they are not already included in the rental cost. Rental or lease to purchase is allowable with OCJP approval. Other allowable costs include software development, general salaries and personnel costs, post-employment benefits. They are allowable in accordance with actuarial requirements and must be paid within 6 months. Consultant fees have a maximum rate of $650 per day or $81.25 per hour. Equipment, software, and hardware, sensitive minor equipment is movable, sensitive property valued between $500 and $5,000. Capital equipment is tangible personal property having a useful life of more than 1 year and a value greater than $5,000. Travel costs and restrictions, travel within Tennessee. In case of agencies that already have written travel policies, procedures, and rates, subrecipients should follow those rates or the lower state rates for travel expenditures, whichever is lower. More information can be found on the state's travel policies by searching State of Tennessee Comprehensive Travel Regulations, and the link's been provided here. Travel outside of Tennessee, reimbursement should follow the appropriate state's CONUS rates, and there's a link here for more information. If costs exceed the approved rate, the grantee will be responsible for the full amount. Again, not just the cost that exceeded the per diem rate. So prior approval is required prior to adjusting the budget, certain line items in your budget amount. This approval must be in writing by OCJP. The following budget items must also be approved prior to being implemented by subrecipient. So again, personnel, if you're moving personnel in and out, you need that prior approval. Depreciation, overtime, staffing changes, capital purchases, sensitive minor equipment, furniture, clothing or uniforms. The one exception to that is going to be emergency clothing for victims or clients, meeting room, audiovisual services, and indirect costs. Funds may not be moved into or out of indirect costs without prior approval. The request must be accompanied by a copy of the agency's approved indirect cost rate or approved cost allocation plan, which includes an indirect rate. And you should have approval letter from the cognizant agency. And I will hand it over to Ben for unallowable costs.
Thanks, Amy. Hey, everyone, good morning. My name is Ben Weinstein. I'm a senior project management specialist over on the special projects unit. And I'm going to go through some of the unallowable costs, which is in the grants manual in the section right after the allowable costs. So the good news is not only will this information be available in your recording of this training, but if you ever need this information, it's very easily accessible in our grants manual. If you have federal funding or federal pass-through funding through our office, then you also may want to check out the DOJ grants financial guide, as well as always check your fund source chapter, which will have sections on allowable and unallowable costs that might be in addition to the general unallowable and allowable costs. So generally, unallowable costs include construction, land acquisition. A big one is supplanting. So that would be using grant funds to replace or take the place of existing funds for an activity or for a staff or for a project that your agency already has. So for example, if you're funding staff with an OCJP grant, what that would require is an overall increase to the full-time equivalent positions in your agency, or you'd have to demonstrate that funding that you have currently is being lost by your agency. Otherwise, OCJP grant funds cannot replace existing funds for any type of activity. Another unallowable cost is compensation of federal employees and travel for federal employees. Bonuses or commissions, including temporary increases to wages, are unallowable. Any fundraising activities are unallowable. That would include the supplies, the time going into fundraising activities. Any type of military equipment is unallowable, and we can, I would say with any of these unallowable costs, you always, if you have questions about whether something qualifies, you can always reach out to your program manager. We definitely have received questions about certain types of equipment. Another unallowable cost generally is any lobbying activities. Next slide, please. Any costs associated with corporate formation are unallowable. Any state or local taxes when assessed, and that should say disproportionately to federal programs. So there are some types of taxes that are allowable. For example, user taxes, gasoline and hotel taxes are allowable, but like state sales tax would not be allowable. Conferences, meetings, and training costs are allowable costs. However, there are some elements of these types of events that sometimes occur that are not allowable with grant funds. Those include any type of entertainment, sports, the cost of visas or passport charges, any tips, any bar or alcohol charges, the cost of doing laundry, certain costs around food and beverages, and then gifts and trinkets. And I'll talk about that one in a little bit. But just, you know, this, I think, some of this is pretty common sense, right? If there's going to be some sort of entertainment on the agenda for an itinerary that you're traveling for, obviously those are costs that have to be borne using non-grant funds or out of pocket. Next slide, please. Moving on, legal fees are unallowable. Gift or gas cards, any late fees that might be associated with, for example, if occupancy or utility charges are part of your grant. Costs incurred during the grant application and any expenses prior to the award date. So I would say 16 and 17 kind of fall into this category of costs outside of your award period. So your contract has a start date and an end date, right? Any costs that were incurred outside of those dates are unallowable costs on your grant. And that includes costs, especially for number 16, that, you know, to submit your application. So if there were expenses that were involved in putting your application together, like a consultant expense or something like that, that would not be allowable. First class travel is unallowable. Management and administrative training, so that would be training for like manager or administrative level staff that are not on the grant. Sole source contracts without prior approval from OCJP. Amy talked earlier about prior approval. Costs incurred outside the project period again. So anything that occurs before or after your project period. If you're amending your contract, anything that would be in your amended contract but occurs before your amendment is effective would be right outside of your project period. Rental costs, if the grant recipient owns or has a financial interest in the property, again, that would go to maybe ethics as well. Next slide, please. Costs associated with severance packages, any interest is unallowable, any credit card fees, membership fees for an organization whose primary activity is lobbying are also unallowable. And then again, I mentioned trinkets earlier. So items like hats, mugs, portfolios, t-shirts, coins, gift bags, et cetera, things like that where, might have a conference name or an agency name on it are not allowable with OCJP funds as giveaways for conferences. If there are, we've got this question before, if there is like an item that has like important information about your program, like who to contact, right, for outreach or something, and you want to put that on some sort of item that is not just a piece of paper, that's something that you can reach out to your program manager about. I think there are kind of ways that we can, if something is useful for your program and has important information on it, and it's not just a trinket, reach out to your program manager and we can see if that's something that would be allowable. Basic supplies that are necessary for use during the conference, like folders, name tags, are allowable as well. Next slide, please. So unallowable costs are not just physical items, but also unallowable activities. So I mentioned lobbying, mentioned fundraising. And again, you can, as I mentioned, find those lists in our grants manual. Unallowable costs and time spent engaged in unallowable activity may never be submitted for reimbursement. So an example would be a staff person who is 100% funded by an OCJP grant may not engage in fundraising or lobbying activities. So that would be not just the items that would go along with that, but their time on those activities. We recommend that agencies that are doing fundraising or lobbying must have clearly defined boundaries and ensure that staff who do that work are not 100% funded by an OCJP grant. The next slide, if you can go to that, has some examples of this. So a common question we get is if I have a staff member who is 100% funded, we're holding a fundraiser event, it's after work hours, it's on the weekend, can this staff member volunteer to assist us? The answer is no. Claims that could arise under the Fair Labor Standards Act and the appearance that a grant-funded employee is engaged in unallowable activities is the reason that this would not be allowed. Okay, what if I have a staff member who is less than 100% funded on the grant? We're going to have a fundraising event after hours. Can the staff member assist us? So in that case, because they're not 100% funded by the grant, yes, they can assist. However, they can't spend more time at that event than they would, spend working on their grant funded job. So if you have a 50%, for example, funded employee, they can't spend more than 50% of their time working on that fundraising event. Next slide, please. Oh, I guess that's the end of the allowable and unallowable activities. So the next slides will be on personnel policies.
Awesome. Thank you, Ben and Amy. Let me see what questions we've gotten here. So there was a question about number 12 on one of the slides, which I believe was a reference to food and beverages. Would they be allowable in a workshop with staff and clients where they wanted to offer light refreshments? So our kind of canned answer on that is no. Food and beverages are not typically allowable with our funding. Predominantly, in terms of like number of fund sources, we have far more federal fund sources where this is specifically unallowable than we do state fund sources. Sometimes that can be allowable under a state fund source. And so if you've got kind of a unique training grant or situation, particularly if it's state funded, I would recommend that you reach out to your program manager to get guidance specific to your project. But as a general rule, no, but there can be exceptions, and your project may be one of those without me knowing the details of your project. As I think about it, another question that comes up is like, well, gee, whenever I go to a conference, right, there's typically like food or refreshments that are available. And so how do those get paid for if not with the grant funding? Or can I pay for those with non-grant funds? And the answer to that is yes, right? When we talk about unallowable costs, we're talking about things that our grant dollar cannot pay for. But if you have other funding streams that can supplement, for example, a conference and can pay for food and beverage, then you could absolutely use that funding to pay for the refreshment. You just couldn't use our grant funding to pay for it. And so again, as we're talking about unallowable costs, we're really talking about the grant dollar can't pay for it, not that it would be like specifically prohibited within the entire scope of what your agency is doing. If my statements there are a little confusing or create too much of a gray area, please reach out to your program manager and we'll be happy to work you through it. Typically what I see us doing is we'll pay for a conference, and then there'll be like, if it's a nonprofit running the conference or a government agency, in fact, they'll have other unrestricted funds that they can use to purchase like snacks and soda and water and that sort of stuff. And that's what they use rather than the grant funds in order to make that available for people. There was a question about late fees. So late fees is really around agency purchases, and so the thought process there is that an agency that's being provided with grant funding needs to be good stewards of that funding and paying bills on time, so that we're not exhausting grant funds to pay for late fees because the agency wasn't making payments in a timely fashion, right? If you're a client services agency and you've got a client that needs specific assistance, and say they need their utility bill covered and it's allowable under your grant, and there's a late fee attached to that utility bill, that would typically be allowable, right? Because that's not negligence on the part of the grant funded agency. That's a specific assistance client need, which is a different scenario. Again, if I've created too much gray with that statement, please reach out to your program manager and they'll kind of walk you through it. I did want to highlight one other thing that Amy mentioned related to hotel costs, because I think that it can be easily missed kind of as we run through these slides. And so if the CONUS rate for a hotel is say $110, which I think is the standard rate for most areas in Tennessee, understanding that Nashville and Memphis and Knoxville and the bigger cities sometimes have higher rates, then we're only gonna allow you to pay the hotel costs that are $110 or less. If the hotel that your individual chooses to go to is $125, well, that exceeds the CONUS rate, and so we're not going to pay for any of it. We do see a couple of times a year where agencies wind up in situations where they think that we'll cover, up to $110, and then they can cover the rest because normally it's a minimal amount, and it's always kind of a shock to them that like we won't cover any of it in that circumstance. So I just want to make sure to emphasize that when talking about per diem and CONUS rates, it's got to be per diem or under for the most part. Now, there is an exception to that when it comes to conferences if your local policy allows for it. The state policy does allow that if you're going to a conference and the advertised conference rate exceeds the CONUS rate, then we do have the ability to approve those expenses. And so a lot of times, like again, let's use our theoretical CONUS rate of $110. The conference rate could wind up being like $210 to stay in the conference hotel. So it's not our practice to require people to find another hotel locally that meets the conference rate. We do have flexibility within our state standards. As long as it's the advertised conference rate, we can pay for it. So what you would need to do is get permission from your program manager and make sure you save the literature that shows what the advertised conference rate is. With those two things in hand, we can approve the hotel at the higher per diem rate. And so if it's like general travel related to your program, whether it's monitoring or just traveling, site visits, TA, anything like that, you're going to be bound by the CONUS rate. If it's a conference where the lodging rate exceeds the CONUS rate, the state standard allows us to do an approval for the higher rate as long as it's the advertised conference rate. Just need to make sure that it is the advertised conference rate. So that is kind of the way to get those conference expenses paid for, because it's typically my experience that the conference rate is always just a little bit higher than the CONUS rate. Let's see. If a 100% funded employee attends an event with their spouse but does not volunteer, is that allowable? So as long as they are attending the event as a normal attendee, and so if it's an event where, say, there's a $50 door charge to get in, that employee and their spouse would need to pay the door charge just like any other attendee. I mean, I'll say just from like the place of perception, right? Like I think sometimes we've seen where employees are attending the conference, but then they had the fee waived and they wind up kind of helping out a little bit. And so that would be an unallowable circumstance as long as it's clearly documented or it's clear that they attended the event as any other person and were not asked to participate in any sort of work or support function with the event, then that would be allowable. Again, if you feel like you're getting towards a gray area of that, reach out to your program manager. And the reason why I keep saying that is because your individual program manager will be the one that does approvals for any sort of weird circumstances and more than likely comes out and monitors you, right? And so if we've reviewed a situation and we said, yes, that's fine, we're going to save that approval in our file. And then when we come out and monitor, we're not going to hold it against you. And so just making sure that any circumstance that seems a little bit iffy, run it by your program manager so we can get an approval in the file, and then you won't have anything to worry about. When submitting the request, what is the required as proof of the advertised conference rate? I mean, like for what I typically see is like whatever's posted on the website, they'll have an individual like statement. And so I've seen people screenshot the actual like web page because you'll want to get it approved with your program manager. Like a lot of times you can give them the link and they can go in and verify and save a screenshot too. Just anything that's produced by the body that's holding the conference that says, hey, this is where we're holding it and this is what the rate is, typically meets that standard. So if it's not a fundraising event, but it's an event normally our entire staff is required to attend after hours, can 100% staff attend? If it's a piece of their required work duties and the purpose of the event isn't to raise funds for your organization or to lobby, then typically that would be something that would be allowed as long as kind of their work there aligns with their goal under the grant. And so what I mean by that is if you're having an after hours staff meeting to kind of talk about like the functioning of your organization or its programs, well, that's going to intersect with the work that they're doing, right? And so that would typically be an allowable circumstance. But if it's an after work event where like non-grant allowable things are going on, that would typically not be an allowed situation. And again, if you've got questions, reach out to your program manager. But yeah, as long as it's like truly business oriented and truly related to like the programming that the individual's involved in, I would typically think that that would be allowed. And then let's see. So if it's not okay, I think I just answered that question. So I believe that I've answered all the questions that are currently in the chat. Really good questions. Always about this section, we start to get these really good like implementation questions. So I'm happy that these are coming forward. I think that I may have missed one about snacks. Can we provide snacks during client support groups? Typically with our federal funding, no, because food and drink is prohibited. Again, maybe our state funding may have some flexibility there, but under our funding, most of the time, food and drink is never allowable, even if it's providing snacks during a client group. If there are no other questions, and there don't appear to be, we'll keep moving forward. And our next topic appears to be personnel files and modifications featuring Mary Beth and Caitlin. Take it away.
All right. Thanks, Jeremiah. So as he said, my name is Mary Beth Howell. I'm a program manager here, and I'm talking about the personnel policies. So in Chapter 6 of our grants manual, that's all about the personnel policy and procedures that are required as a subrecipient. So there's some pretty specific information in both this presentation and in the manual. So it'd be pretty important for you to familiarize yourself with that section and just to refer back to it whenever you have questions. Like we've all said, your program manager will also be a good source of information, but the manual is very thorough on this topic and very helpful. So we're just going to go over a few things in this section that we felt like it was important to highlight to you. So for starters, as a subrecipient, you're required to have written policies and procedures regarding your personnel. Those will include all of the things that you see listed here. Most of you will already have this in some form or another, but you just want to go through and make sure that these are all complete and up to date, and that your board or your leadership has reviewed it and that everyone is comfortable with what these policies or comfortable with the policies prior to entering into contract with OCJP. When we come out to monitor, we'll be looking for these policies specifically. Some of these policies, OCJP has specific wording or requirements that must be included in your policy. So please be sure to check the manual for those requirements and compare them to what you have in place to make sure that they comply with those additional requirements. I know that Aaron and Haley touched on this a little bit earlier, like on the LEP policies. And another example of that is the nepotism policy. We required the definition of relative to be included in that, and that definition is from the Tennessee Code annotated. And another one of these is with additional requirements in background checks, and I'll go over that more in depth in just a few slides. Next slide, please. So here are the requirements of your agency's personnel files. When you are monitored programmatically by OCJP staff, we'll be checking through all of these things to make sure that they're in there and that they are up to date. So some of these things that you would have as part of the hiring process, like documentation of reference check, application or resumes, signed release of information for a background check results, job description, things like that you would already have. Other things that you would need to add kind of as they happen. So this would be like training certificates or training logs as hours are completed. We'll need to see a record of the required trainings listed here, but it's always a good idea to put any trainings documentation that was completed in those files. It's just a good place to store all of them, even the ones that are not required. So anything that you do with your staff, you'll want to keep all of that in their personnel file and ensure that they are complete and up to date. Again, all of this is listed out in the grants manual if you ever need to reference that. And then you'll see down here at the bottom, it mentions 100% certification, if that's applicable. That's something we'll talk about in just a few minutes, so that'll make more sense then. Next slide. Like I mentioned earlier, OCJP requires that your agency have a background check policy for your personnel. We don't necessarily have a set policy that we require. However, we just want to ensure that whatever your agency's policy is, that it meets our minimum qualifications and that your agency is adhering to that. So all personnel at your agency must have a background check. The policy must require a statewide name-based background check for all states where the individuals have lived, worked, or attended school in the last 5 years preceding the background check. Individuals who are transporting clients must also have a driving record check and proof of insurance liability. There are also additional requirements listed here that we will address on the next slide. If you want to go ahead and move to that one. Okay, there it is. So any person, including but not limited to staff, volunteers, interns, subcontractors, or consultants who are reasonably likely to interact with clients who are either minors or vulnerable adults. There are additional requirements of criminal background checks and the public sex offender registry check. So the criminal background check must include fingerprinting, and this must be repeated every 5 years. This is just an additional layer of accountability and protection for you and your staff, and most importantly, for the clients that you serve. So please review Chapter 6, Section 1 of our grants manual for more information on those requirements if they apply to your agency. And also make sure that whatever is in your organization's policies regarding background checks is parallel with what is identified in our manual. Next slide, please. So agencies must properly verify the employment eligibility of anyone who will be funded with grant funds. This is done by I-9. You can choose to participate in E-Verify. The link for that is listed here, and there's also a training available for your agency that you will be responsible for if you choose to utilize that program. Next slide. So regardless of if your agency chooses to utilize the E-Verify, we do require that your agency collect and review the following documents according to this timeline. So prior to the employee's first day at your agency, their I-9 form must be complete. And then prior to the employee's third day, they must have provided copies of their original ID documents that are required by this form. We require that the copies of these forms of ID are kept in the personnel files. The copies must be front and back. And so when we come out to monitor, we're going to be looking that those copies are in there and that they are, that front and back are visible in the file. All documentation regarding the I-9 must be maintained in accordance with the I-9 record retention requirements. Those requirements and any additional information you may need, again, are in Chapter 6 of the Grants Manual in the section titled Policies and Procedures. Next slide. Okay, so it's very important that you track how your paid staff are spending their time because you'll be reimbursed for that time from the grant. So there's some pretty specific instructions in the manual around how to track that. You can see here that we don't dictate what form your agency uses. So you're not going to find like a template in the manual or on our website, but you can use whatever form your agency finds most helpful. It has to contain all of the information that you see listed here, and this is going to be requested by your program monitor as well as the fiscal monitor at some point during the life of the grant to make sure that it was tracked appropriately. Next slide. So there are two categories of paid funded grant staff. And there are those that are 100% of their salary comes out of the grant, and then there are those who only a portion of their salary is paid from the grant. It should be outlined in your budget which percentage each funded employee is and what percentage of their salary is paid by the grant. So this is an important distinction because it determines what kind of tracking for your time is required for those staff. Anyone who is spending less than 100% of their time on the grant must keep an activity log with required information from the previous slide. So if we go to the next slide, there is actually an example of what an activity log could look like. So again, we don't have a template that you'll be required to use. Most people use either like a calendar or a spreadsheet to do this. As you can see, it has to include the date and the project they were working on, the specific activity, and the time spent on each activity. I would also suggest writing, instead of just writing which fund source it comes from, to also include the contract number, because I know some agencies hold multiple, like let's say VOCA, for example, they've got multiple of those contracts. So be sure to include that contract number as well. We'll also need to see the employee's name, job title, signature, and the supervisor's signature in this activity log. However, this was just a snippet just for the purpose of seeing how someone might track specific hours and activities. So this is the kind of thing that if you're not sure how to do it, or if you have questions about the way you're doing it, talk to your program manager ahead of time, because it's much easier to get this right as you go along rather than trying to correct it retroactively, just in anticipation of being monitored. Okay, next slide. So the other type of grant funded staff is that 100% funded from a single grant, which we've been talking about some. They don't necessarily have to keep a time log, because we expect that everything that they're doing is directly related to the grant. So rather than a specific time log, they're required to sign what's called a certification of time charged form. That form is linked here in the PowerPoint. It's also linked in our online manual. And if for some reason you have trouble finding it, your program manager can also send it to you. It's a very simple form that requires people who are funded 100% on the staff or on the grant for 6 months or more to sign and keep that in their personnel file. And this would typically be done at hiring if this was applicable to them. Again, at the time of monitoring, you'll be asked to produce this certification for each of your staff that was received 100% of their salary from the grant. And it says here at the bottom, if you have an intern or a volunteer that you're using as in-kind match. So you're not paying them from the grant because they're a volunteer, but you are valuing their time and then billing the grant for that under in-kind. Then they also must document their activities just as a paid staff person would. So if you have questions about the logistics of that, your program manager will be very helpful. And I think the next slide is where Jacqueline is going to pick up for us.
Hi, I'm Jackie. I'm filling in for Kate because she is on leave currently. As a project director of an OCJP grant in a nonprofit or any other organization that is receiving funds from OCJP, there are things you have to keep in mind, and that things you will have to notify your program manager about throughout the course of the grant. One of these things has to do with personnel, and you will need to notify your program manager if there are any changes in the personnel who are paid under the OCJP grant. If there are any changes with your personnel, they need to be reported to your program manager within 10 days of the change. And this applies to also anyone besides staff. This applies to anyone who was named as one of the 3 key grant positions: the authorized official, the project director, and the financial director. We have a tool called a personnel spreadsheet, and this spreadsheet asks that you list all your staff who are employed under one of the OCJP grants at the beginning of the contract year. It sets the stage. It has the name, the position number, whether there's a job description, salary, numbers of hours of the full-time employee, and whether it's 100% or a smaller percentage. All of that is on the spreadsheet, and then if there are changes throughout the course of the year or the life of the grant, which can sometimes be up to 3 years, every time there's a change made in staffing, you will need to submit an updated personnel spreadsheet that has the changes highlighted and the date of those changes and when they were reflected. Your program manager will keep each submission of the personnel spreadsheet on file, or you can request a personnel spreadsheet from your program manager once a year. You should also maintain a copy of the spreadsheet in your grant file. Lastly, if you do have a vacancy in one of your staff positions, please remember that you have 45 days to fill that position. Failure to abide by this requirement may result in the agency losing the position in question. If the position is not filled within 45 days, you must submit to OCJP via your program manager a letter from the authorized official justifying the delay in filling the position, and you have to explain in that letter how the program is providing services while the position is vacant. After the 45 days, you will need to send a monthly report to OCJP of this information until the position is filled. Again, once the vacant position is filled, please notify OCJP in writing within 10 business days using the personnel spreadsheet. And next slide, we have what the personnel spreadsheet looks like. There it is. The first tab is for there's tabs on it, and I don't know if it's showing on this, but at the bottom, because there will be tabs. And the first tab is for your current staff. That will need to stay up to date and reflect any changes, if there are any, and if you could please highlight in yellow any changes. When filling this out, it's a pretty self-explanatory chart, but you will need to fill out the position number, the employee name, their title, whether there's a job description, salary, number of hours of the full-time employee, and whether it is a 100% or smaller percentage of their salary. And next slide, please. So this would be the tab for former staff on the grant. If there are any changes and a staff person no longer works under the grant, they will be moved to the former staff tab from the current staff tab. So you'll use the next tab. The former staff tab is basically for records purposes and to see the history of the position. And next slide, please. So this will be for PRN staff and overtime staff. This is for staff that work on a as-needed basis. These individuals most likely do not have a set schedule, or they could be individuals who are not in an OCJP grant-funded position, but who have filled in for someone who may be out. Of course, if there are any changes in staff, please ensure you are sending an updated personnel spreadsheet to your program manager with any changes highlighted, and please keep a copy of the spreadsheet in your agency file. Next slide, please. So this slide is going over hiring staff. There's also a section in the grants manual that highlights the personnel qualifications, but as part of your solicitation or application process when you are applying for the grant, or when you did apply, you would have been, or you will be likely to required to submit job descriptions that establish the qualifications for each position that you're hiring. The idea here is that you have a job description and then you receive the funding, and then you start to find individuals who you want to hire for these positions that fit that job description. So we're going to be checking to make sure that the people you are selecting to hire fit the job description that we are funding. Also, OCJP must approve prior to employment for any grant employee not meeting the requirements that you initially laid out. If, for instance, say you have a position that requires a bachelor's degree, but you have a candidate who applies and it is working on their bachelor's degree, but they don't have it yet, but instead they have 10 years of experience specifically in the field that you're hiring, that would be okay. But this would be something that you want to reach out to your program manager about. And you would request a written waiver of personnel qualifications, and that must be must be requested prior to the employee's employment. The written request for the waiver must explain the reason or reasons for employing a staff person who does not meet the personal qualifications, and a training plan must be included that ensures the employee will maintain a consistent level of understanding on how services are to be provided under the grant-funded position. So this would also be a conversation you would want to have with your board of directors or your agency leadership, just to make sure everyone is on the same page. Lastly, if approved, a copy of the request for waiver must be maintained in the employee's personnel file, and the waiver will approve the period of the individual's employment in the position, and it is only applicable to that individual. So you can't use it for other employees. Next slide. You are required to have written policies and procedures that reflect the things that you have seen here in this presentation. So that's also listed in the personnel qualification section as well. But again, these are the sort of things that when you are monitored, your program manager will check in your actual policies and procedures manual or your employee handbook and make sure that the pieces laid out are clearly laid out and that you are following what is in those guidelines. And that's all from this section. Thank you.
Awesome. Thank you, Mary Beth and Jackie. And we are at our second break, but let me go over the questions here for just a moment. Sorry, I'm still scrolling. So there was a question about if the grant is not paying for your staff, do the personnel file requirements, is that still a requirement? And the answer is no. The section on personnel is really only for grant funded staff, and that's staff who are funded partially. So any piece of their salary is funded by the grant, or in whole, which would be 100% funded. But if your grant is not paying for any staff, then we are not laying forth personnel file requirements on you. There was a question about, could the supervisor signature on an activity log be the program director? Potentially, yes. I think for us, it's primarily to make sure that the grant funded staff member is the one generating the activity log. And so we would not want to see a situation where the project director in this case, or supervisor, is basically generating and signing the log as true and correct. One of the specific things when we come out and monitor is we will do employee interviews, and we will talk with them about the process for generating time and activity logs. And it's always a concern for us if we hear that the individual employee doing the work isn't controlling or isn't reporting their own time, right, that it's being kind of doled out at an administrative level, because our specific concern is to make sure that hours charged to the grant are actually hours worked, and that staffing loads aren't being balanced just based upon like a proportion of grant funding available to the agency. That starts to get really into fiscal stuff, which is the purpose of the meeting this afternoon. But I did just want to emphasize that in terms of creating timesheets and creating activity logs, that's really up to the grant funded staff member to generate, even if it is reviewed by the project director or supervisor. Drop a link for the certification of time charged. Yes, we can absolutely do that. I don't know if a member of the team can grab that really quick and reply to your comment. If not, I'll catch it during the break. There was a question about the certification. The 100% certification only is due at the 6-month period. And so that is correct. And so, you know, what we see effectively is that you'll have 100% grant funded individual on your grant, and then maybe they resign and leave your organization. And for a period of time, the work that they perform is like absorbed by one, or, you know, if it's 100%, potentially multiple different people within your agency. We would need to know that those personnel are now attached to the grant, but you would not have to fill out the 100% certification unless they were going to fulfill that role for greater than 6 months. There's a question, does the certification of time need to be completed every fiscal year? As if the person's consistently assigned 100% to the grant, you do not have to re-sign that certification every year. No, you would do it, you know, when they're first appointed to that position within the first 6 months, and then it's good until they're no longer on the grant. There was a question, the 45 notification. So the requirement is if a grant position becomes open, your agency is required to notify us within 10 days of the opening, and then every 45 days that it remains open. And so the question is, if it's a new grant, do you have to start that 45-day notification cadence even when the position has not fully been filled? So that my response to that is yes, that is what we would anticipate receiving from your agency. We get it. Obviously, we work with a lot of grants, and we know that when you start a new project and have a new position, sometimes it can take a little longer to get those positions filled. And so, you know, the fact that a position is open 45 days at the beginning of the grant, that's typically not something that we're super concerned about, as long as you can demonstrate the activities that you're doing to work towards filling the position. Where I think we would have concerns is that, you know, the position was created, it's new on your grant, it's not been filled, and now we're 9 months into the grant, a year into the grant, and the position still has never been filled, right? And so that's why we would want to see those 45-day reports, because an extended period of time like that a new position was created for your agency and unfilled could be an area of concern for us. And Jesse, I see your hand up. Would you like to respond as well? This is Jesse Cleveland, our Assistant Director of Special Projects.
Sorry, I'm working on cutting my camera on screen. Hey guys. Yeah, another sort of thing I would just add to that, Jeremiah, I'm so glad you guys are talking about that, is that an incentive for keeping your program manager updated about your struggles to fill a position is that there's a lot we can do to help support you in getting that position filled. That's a really common issue that a lot of our agencies struggle with across different projects. And so we have all sorts of tools in our toolbox that we can pull out to help you. We have professional networks we can connect you with. We have all different programs have different like resource lists of like common places that professionals, you know, look for job postings. We can float it out to our other stakeholder groups that we maintain at the state level. So we can really help you get the word out to fill a position. And so, you know, definitely let us know as soon as possible if you're just finding like, man, we're just really having trouble like getting a warm body in here, getting a person with the right qualifications maybe. So yeah, that's just another reason to keep us in the loop on that, because we can really help to support you in a bunch of ways to actually get that position filled quicker and better. Thanks, Jeremiah.
No, thank you, Jesse. Great information. Let's see. So is the staffing spreadsheet only required to be updated when there are changes in the position, but not annually when there are no changes? Yeah, that's correct, right? If you've got a 3-year grant and year 1 ends on June 30th and then year 2 picks up on July 1st and there's no changes in staffing, we would not anticipate you sending us a new staffing spreadsheet because you're rolling forward with the new staffing pattern. I would say the exception to this, although it's not really an exception, is that if you were to get a new grant contract, so say you've got a 3-year contract, ends on June 30th, and then a new grant contract starts on July 1st, we would consider that to be a different program. Even if the positions are the same, we would anticipate you sending us a personnel spreadsheet. It could be literally as simple as like taking the old one, refreshing the dates to show that they just started on the new project and sending it to us. But for a grant that rolls multi-year, you don't have to resend that personnel spreadsheet every year if there's new changes. We really only want updates when changes occur, and then we'll ask for confirmation that the sheet is correct when we come out and monitor, so we know who to set up employee interviews and such with. If an intern is not paid with any grant funds, do they still need to complete the I-9? Does anyone on the team know the answer to that off the top of their heads? Otherwise, we may need to do some I-9 research. I don't know if Ron is present.
I believe all interns have to complete I-9s. This is Jackie. But yeah, I believe they do.
Okay, that would make sense to me given the guidance, but Scott County Family Justice Center, we're going to make a note of your request and see if we can do some quick research here, and if not, we'll provide that answer to you independently, and then when we release kind of all the materials next week, we'll make sure that that question's answered as well. So if I can ask someone on the team to make a note of that, because I want to make sure that we give the correct answer. And then, see, Valerie provided the link to the certification of time charged. Thank you, Valerie. And then last question I've got is on the personnel spreadsheet is hiring date, the date of contract start date if the employee was hired before the contract start date. So hiring date would be the date that the individual is actually hired into your agency. And that's important. I'm glad that you brought that up because it's important for one reason, for like a key reason, right? One of the personnel file requirements is that like that there's a reference check conducted. And so I've personally experienced situations where a county government has started a grant program and they've moved someone who may have started with the agency, like literally, I think in this case, it was like the mid to late 90s, they were being moved into a grant funded position. So we recognize that their personnel file may not have references that go back that far because they might not have had a policy in place in order to check references, right? So we would in that case know based upon the hire date that that's a requirement that doesn't make sense for this employee. But if they were to leave and then it were to be filled by a new individual because they were newly hired into the position, we would expect for then the reference check to be completed as outlined in the manual. And so it is not the contract start date, it is the hire date within the agency if you're moving someone existing into the grant position and then backfilling their old position. Their hire date would be the hire date with your agency. And that's why the example I gave is one reason why that it's important to have that piece of information. Seeing no other questions, we are still, looks like pretty well ahead of schedule here. So let's come back at 10:20. Again, if you haven't logged in already, the tiny URL link on the page, if you go to that, fill in your information. I think we've gotten our program managers and fund sources updated now. If you've already signed in and just picked one, following my other guidance, that's perfectly fine. We'll marry you up on our end. And I will also put the full link to that form into the chat for those that still may have trouble with it. You only need to fill this out one time during the day, including the session this afternoon. So if you've already done it this morning, you don't need to do it again. I'll get that link in the chat. We'll do some research on the I-9 and we'll be back at 10:20. Thanks, everyone. Hey, Robin, do you mind backing it up one slide so the break information with the links available?
Sure, I'll do that.
All right, welcome back, everybody. I have 10:20 Central Time. Wanted to circle back to the question in the chat related to I-9s and whether or not if an intern is not paid with grant funds, do they still need to fill out an I-9? Unlike our previous guidance that was specific to grant-funded personnel, we did go to the U.S. FAQ related to I-9s, and I've pasted that as a response in the chat, but I'll read it to the group. It says USCIS is frequently asked whether an unpaid intern needs to complete Form I-9. In general, an unpaid intern does not need to complete Form I-9 unless he or she will receive remuneration, which is something of value such as no cost or reduced cost meals, lodging, or other benefits in exchange for his or her labor or services. For more information about remuneration, see the Form I-9 Central Questions and Answers, which is linked in the chat. And so if an intern is truly unpaid and does not receive any sort of remuneration, then the answer is no, an I-9 would not be required based upon this FAQ. With that question hopefully answered, if there are still questions about that, please let us know. We will move forward to required notifications featuring Gary Lee. Gary?
Thank you, Jeremiah. My name is Gary Lee, and I am a senior program manager here at OCJP, and we will be discussing required notifications. This information regarding notifications can be found in our grants manual, Chapter 2, Achievement of Operational Status, Section G. Now, we have about 15 notifications that we have listed in this presentation, but if you are, as an agency or the project director, have any questions on whether or not you should notify OCJP, I encourage you to have that conversation with your assigned program manager. Let's go ahead and get started. An agency must provide an email notification to your assigned OCJP program manager within 10 days from the date of occurrence of any programmatic or administrative changes related to the contract. Remember, all email correspondences related to programmatic or administrative changes must also be saved within your grant file. Let's begin. The first one, any change in or temporary absence of one of the three key positions to include the authorized official, project director, or financial director. Note, this includes any change in their contact information of a person filling one of these three roles, including phone numbers and email addresses, etc. If there is a stoppage or interruption of implementation of project activities arising from litigation, loss of staff, or program restructuring, a notification is required. If there is a change in project site or location, as well as a change in scope of program activities or project purpose, make sure you notify your OCJP program manager. If there's an addition of equipment and/or sensitive minor equipment to the project budget not previously identified in the contract, make sure you notify your program manager. Also, a change in grant-funded personnel positions and/or temporary staff changes. Any vacant positions must be reported within 10 days. This information was also previously mentioned and discussed in the previous block of training, but just be mindful that vacant positions must be filled within 45 days of the date of the vacancy. If the position is not filled within 45 days, the agency must provide a status report to OCJP for that position every 30 days. And we also discussed in that previous block of training about utilizing the personnel spreadsheet to notify OCJP of any staff on the grants and any staffing changes made throughout the life of the project. Let's go ahead, next slide. Moving on, any updated renewal dates and/or changes in your U.S. federal government System for Awards Management, also known as SAM. This includes any changes in the UEI number. The UEI is your unique entity identifier. Receiving additional federal grant funds in conjunction with a current agency project being funded by OCJP. If there is a change in the agency's banking information that is being used for direct deposit of OCJP grant funds, your agency must submit a completed original automated clearinghouse form and submit it to the address below. Any change in the individual responsible for reporting civil rights complaints or any adverse findings of discrimination. Any lawsuits filed against an OCJP funded program or project. And please note that all notifications of EEOC claims or lawsuits must follow the procedures outlined in our OCJP grants manual listed in the slide. Any formal allegation of civil rights discrimination, including those related to employment, require the agency to immediately notify the OCJP Civil Rights Coordinator at ocjp.compliance@tn.gov. The last two, if a federal or state court or administrative agency makes an adverse finding of discrimination against your agency after a due process hearing based on race, color, national origin, religion, age, sex, or disability, your agency must email a copy of the finding to ocjp.compliance@tn.gov within 45 days. And lastly, if an agency has been designated as high risk by a federal or state grant making agency, your agency must complete a new high risk designation certification form and email the form to your assigned OCJP program manager within 10 days. And just remember, email your assigned OCJP program manager within 10 days from the date of occurrence of any programmatic or administrative changes to the contract. At this time, I'll turn it back over to Jeremiah to see if there's any questions in the chat.
Thanks, Gary. We had one question related to number 5, which is notification around the purchase of sensitive minor equipment, if that would also require approval, and the answer to that is yes. And so the way that we implement sensitive minor equipment, and again, that's tangible personal property with a value of greater than $500 up to $5,000, not to be confused with equipment or capital purchase, which is $5,000 or more. Although for the purposes of this conversation, they're more or less the same, right? So if your budget states that you're going to purchase 3 laptops for grant funded staff, and the total cost was going to be $2,000, and that's already a specific line in your budget, you would not need to contact us about purchasing those 3 laptops for $2,000. If, however, let's say the laptops came in at $1,200, so you wind up having $800 still in sensitive minor equipment that you wanted to make another sensitive minor equipment purchase with, we would need to be notified, and we would need to approve that because it would be a variance essentially from what was already budgeted in your grant. And so if you're ever going to use funds to purchase sensitive minor equipment, and the reason why that's most relevant is because it's within the supply item. So a lot of agencies have a certain amount of money in supplies that could theoretically be used for that sensitive minor equipment. If it's not specifically stated that you're going to purchase sensitive minor equipment and what you're going to purchase in that budget line, you would need to seek our approval prior to making those purchases. There are no other questions. We're good to move forward to our next section, which is grant project modifications and amendments. And Gary, I think you've got this one as well.
Thank you, Jeremiah. Let's go ahead and next slide. This information can be found in our grants manual. There it is, chapter 17 and chapter 18. And we'll be discussing a narrative and scope of service revisions. Just remember, project revisions are not automatic. We encourage you to assess your project 3 to 6 months after starting each fiscal year or from the original date of the contract begins. We also encourage you to consult your OCJP program manager to evaluate the need for a modification or a revision. Please note that project revisions may be considered for minor changes, and any project revisions, you must obtain prior written approval from OCJP. Now, regarding budget revisions or modifications, agencies can utilize the OCJP 20% rule, providing that the cumulative amount of a line item, increase or decrease, cannot exceed 20% per fiscal year. Also, movement of funds does not include line items with $0 amounts. Any increase to a line item must be offset by an equal reduction of one or more approved line items. The movement of funds does not change the project's purpose, goals, or intended outcomes, and the movement of funds must adhere to all other applicable OCJP grant requirements. Agencies requesting to utilize the OCJP 20% rule to move funds into or out of salaries, depreciation, indirect cost, or in-kind match require the following: prior approval from OCJP, a copy of the agency's approved indirect cost rate, and a copy of the cost allocation plan. Please note that the cost allocation plan should include an indirect rate if altering the indirect cost line and a new depreciation schedule if altering the depreciation line. Additional budget line items requiring OCJP approval prior to revising or modifying include the following: salaries, overtime, changes in staffing positions added or deleted, capital purchases and/or sensitive minor equipment, furniture and/or clothing to include uniforms, meeting room audio and visual services. Remember, a separate approved line item must be reduced by the corresponding amount, and the reduced amount cannot exceed 20% of that line item. For example, using the computer as an example for this one, agency needs a new computer costing $600. The agency budgeted $3,000 for supplies and $5,000 for training. Utilizing OCJP's 20% rule, the agency can move no more than $600 from the training line item into the supplies line item. Also note that do not change column A of the OCJP invoice reimbursement form. Switching over to contract amendments. Amendments are considered on a case-by-case basis and not automatic. Any proposed changes must be submitted in detail via an email to your assigned OCJP program manager. Our office will review the requested changes and determine if they warrant an amendment to the contract. If approved, OCJP will initiate the amendment process. Please note that an amendment is not official until it has been signed by the Commissioner of the Department of F&A. Program narrative amendments. The justification for an amendment must demonstrate a significant change in the following areas: target population, project goals and/or objectives, project and/or collaborative activities, performance measures, project expenditures, staffing changes, and multi-year goals and objectives. Budget amendments are also considered on a case-by-case basis and not automatic. Any proposed changes must be submitted in detail again via an email to your assigned OCJP program manager. Budget amendments are required when total federal or state funding amount of a grant contract is increased or decreased. Also required if movement of funds between budget line items is greater than 20% of the line item amount. Budget amendments can only be done for current or future fiscal years. We cannot go back in time. And when completing a budget amendment, it will require an updated detail and summary budget page. Moving on to agency name amendments. An amendment is required when the legal name of an agency has changed. The request must be submitted in an email to OCJP along with copies of the official supporting documentation. This usually involves nonprofit agencies and results in approval of the amendment to the charter on file with the Secretary of State. Once approved, OCJP will amend existing contracts to reflect the change. Grant project modifications and contract amendments, just remember to save all pertinent correspondence related to project modifications and/or amendments. This concludes this block of training. I'll turn it back over to Jeremiah for questions regarding this subject.
Absolutely. Thank you, Gary. So the only question we got during that section was related to the 20% rule when it comes to movement. If you're not super mathematically inclined or uncomfortable, definitely work with your program manager in order to like verify that it's being done correctly. But specifically speaking, the question was about, is it 20% of your overall budget, 20% of specific lines? And the answer to that is it's 20% of the lowest line involved in the transfer. And so if you imagine if your budget was simply 2 lines, line 1, let's say you had $1,000 in supplies, and line 2, you had $10,000 in travel, and you wanted to move funding from line 1 to line 2, you would be limited to $200 because that's 20% of that $1,000. Likewise, if you wanted to move money from the 10,000 to the 1,000, you would also be capped at $200 because that's 20% of the lowest line involved in the transfer. So whenever doing 20% movements, it's always going to be 20% of the smallest line involved in the transfer in terms of the cap. And with no other questions in the chat at the moment, we'll move to the next section, which is our fund source chapters. And it looks like we've got Kim and Susan. Kim and Susan, take it away.
Okay, good morning, everyone. We can move on to the next slide. Okay, so this is just a picture of where to go in the manual and what that page looks like when you go to look at the specific fund source chapters. Next slide. And so in this chapter, you'll see there's a piece on eligibility, program purpose, program priorities. But I will tell you, all of our staff still, we all go to the manual probably on an almost daily basis. And so anytime I'm going to the manual, I see that I'm probably most likely going to allowable and unallowable costs. So that's maybe where you spend most of your time. So if you're a VOCA recipient or JAG or whatever it is, you can go to the specific fund source chapter for that fund source to really hone in on some of the specifics of the allowable and unallowable. Okay, we'll go to monitoring. All right, and Kim's going to start us with monitoring, and then I will come back and finish this up.
Good morning. So with monitoring, we have 2 different purposes. One is where we do programmatic monitoring, and that determines a subrecipient's compliance with the requirements of state and/or federal program standards, fund source legislation, applicable laws and regulations, and stated results and outcomes. We also look to ascertain if internal controls over financial management and accounting systems are adequate to account for program funds in accordance with state and federal requirements during fiscal monitoring. Monitoring ensures that activities are in compliance. You'll see several items listed there. You can go to these each individually to get more details about those. Next slide. And monitoring supports the OCJP mission by providing technical assistance, achieving improved subrecipient grant implementation, and sharing in OCJP outcomes as an integral part of its success. There are core areas that we look at when we're doing monitoring. So with program monitoring, we're looking at activities allowed, and that is seeing if the activities that are being done match up with the fund sources. With eligibility, we're looking to make sure that the clients that are being served are eligible for the services based on your contract and on the solicitation. With reporting, we're seeing that the agency has a system for gathering data, which matches the numbers that are submitted on your reports. And special tests and provisions, looking to see if you're using the data to match up with what's documented in client files and in interviews with staff. and also making sure that you are compliant with civil rights. Later today, we will talk, fiscal will talk more about the details that they look at with fiscal monitoring.
Okay, so selecting contracts for monitoring. So I always say every year, because I've done this part several times, we're not just throwing your agency's name in a hat and just randomly pulling. There actually is some thought behind this. And every year, at the beginning of the fiscal year, we're completing risk assessments on every program. So we're looking at how much money you're receiving. Have you had any issues in the past with maybe some program performance? Have you had a lot of turnover? And turnover doesn't necessarily mean something bad is going on, but it just means that we've got a lot of new players who are trying to work with these projects. And so we want to, that might be, that's going to score you pretty high. So we may be coming in just to make sure that everyone's, working on this grant the way that they're supposed to, and the outcomes are being met. So so definitely we're looking at those risk assessments, and if you score high, so again, it does not matter. It does not mean something bad if you score high. All high-risk contracts will be monitored in the year, and then all contracts will be monitored at least once in the lifetime of the contract. Next slide. So the process, we have fiscal staff, and of course we have program staff. We may or may not conduct these monitorings at the same time. We try to if we can, but sometimes it's just not possible. There's certainly a lot more program staff than there are fiscal staff. So it just sometimes is not aligned for us to come at the same time. We will send a confirmation letter out to you. And I know we talked a little bit this morning about the confirmation letters. But before you get that, it's not a surprise. Typically, we have been on the phone with you and we've kind of worked out a date that works good for everyone. But you'll get those. You will get an official confirmation letter sent to you. It will go to your authorized official, and then program staff will be, and fiscal staff will be copied on that. And then we'll probably send it. I know when I send them, there's a separate email that comes right after that where we're asking you for some documentation to send to us ahead of time. So it's things that we can be looking at ahead of time, maybe some of your policies and procedures, things that will help us make the best use of our time once we actually get on site. Next slide. So when we get on site, it starts with usually an entrance conference. And I know that sounds very formal, but I know for me and some other staff, they're not super formal. It's just a time when we can get around the table and meet with any staff that you want us to. There may be a board chair there, or it may be sometimes just the executive director or the project director. And we just kind of map out the day, kind of tell you what we've got in mind. You can ask us any questions if you want to at that time, but just a kind of a time for us to kind of set the stage for the day. We'll do interviews with staff. We will review your grant file. We'll be looking at policies and practices. And again, some of these things we will have looked at before we came. Not typically client files. So we'll look at those on site. Those are redacted files. We're going to look at your review of any subcontract that you have. So how are you ensuring that your subcontract is meeting also the needs of the grant? And then we'll do an exit conference, which again, we're just bringing everybody back in, kind of talking about some of the things that we may have concerns about. We may have some more questions for you if there were any holes that we I couldn't find this, I couldn't find that, and then you could show those to us, and then we will do a follow-up and a survey so that you can tell us how we did for our monitoring. Next slide. Okay, so after we monitor you, within 30 days, you will get your written monitoring response, right? Your monitoring report from us. So if there's no findings, then yay, there's nothing to do except just keep doing what you're doing. And there's nothing you have to do. For findings, if there are findings, there's a written corrective action plan that you'll have to do. And there's a template for that in our manual that you can find, where you're simply just stating what the finding was, and if and whether or not you agree with the finding, and then you're going to state what your what your resolution is to that finding. And then, of course, you'll be submitting any backup documentation that you need. So, for example, if you had a policy that was not compliant, you'll just submit the policy, then your revised policy with your corrective action plan. And observations, that is something that may not rise to the level of a finding, but it's something that we feel like is at least something that needs to be noted. And so that follows the same the same process as a finding, where you'll do a corrective action plan with that also. And also, these corrective action plans need to be signed by your board chair.
All right, so with your corrective action plans, there is a template in the OCJP manual for you to use for this. On this template, there's a notice of agreement or disagreement to each finding or observation, a detailed plan of how the agency will correct each individual finding to prevent this or similar findings in the future, or if the subrecipient disagrees with the finding or observations identified, there's detailed documentation must also be submitted to refute. Repayments of all questionable costs listed in the monitoring report, and attachment of any subrecipient documents, forms, policy changes, reports, accounting tools, timesheets, data collection forms, etc., that ensure the subrecipient has corrected the findings and following the CAP. The corrective action plan must be signed by your authorized official, so no designees, no project directors, and must be submitted no later than 30 business days after the issue date of the OCJP subrecipient monitoring report.
Okay, so common issues. So these are just some common things that we find when we come to monitor. Unallowable costs, purchasing things that is not allowable to do with the grant. Proper notification to OCJP. So this is like if you fail to let us know that you've got a new authorized official, or there's a new project director, or someone who's involved in the grant. Sometimes we find these out by accident, and so we're always coming back and saying, when did that person resign? And so we definitely have to have those within 10 days. And I know we talked about that earlier. Some of the things that I'll go over are things that we have previously mentioned today. Achievement of operational status. So if your program is struggling, let's say you get a contract starts July for some programming, and you are at like 3 months in, and you've had trouble hiring a project director, or maybe you hired your project director, but you were supposed to be collaborating with another agency, and you've had trouble getting that agency involved, and the project's just struggling. That's something that we need to know about. So, don't certainly wait till we come out to monitor. And actually this year you'll be hearing from your program managers probably a lot more. At least once a quarter, you'll be hearing from them. They'll be kind of checking in with you in different ways. So that's a really good time to talk about those things. So we're trying to head off any surprises and just help you make your project even stronger. Prior approval, it's just not getting prior approval for maybe some of the things like Jeremiah talked about, like the sensitive minor equipment. And of course, if you've got some if you've got some unallowable costs in there. And let's see, also nepotism policy. I will mention that was something that we saw a lot this year. So if you got a finding for that, you are not alone. That we had several that got that, and they were, and a lot of times programs would either not have a nepotism policy, or they would have one, but it would not have the correct relationships defined in the policy. So the best thing to do is just copy the one straight out of our manual, and then you're sure to get no findings on that. Sometimes we'll see findings around just not having the required training. Maybe folks have not done the Title VI or victims comp training, or sometimes we'll have no board trainings for the board members. So definitely make sure you're getting all your trainings done. Next slide. Failure to invoice in a timely manner. We really want people to invoice at least once a month, and but no later than once a quarter. So please, if there's any way you can invoice us once a month, that would be perfect. But the folks that don't invoice for 6 months, 7 months, there could be findings for that. And of course, just deadlines and reporting, getting your reporting in on time. And all of the reporting due dates are all in our manual. So I believe there's a chart that has them all in there. So they're very accessible. So no surprises. Common issues, of course, project implementation. So are you following your scope of service? Are you doing what you sold us? Because when you all have a contract and you submit your application through a solicitation and we accept your contract, we're kind of buying that project from you. So if you have got your contract and you've 6 months ago buying, like, this isn't really working, we want to do something totally different. And you start making a lot of changes to your project, that can definitely affect your project implementation. That would be an issue. Data collection, are you tracking data and reporting data accurately? So when we come and monitor, we're going to pull a sample and we're going to say, okay, for this quarter, show us how you got these numbers. So we're going to want to see that your data collection process was able to produce the same numbers that you gave us in the report. And then, of course, releases of information. We've pretty much got those tightened up, I think. Several years ago, there was an issue with releases of information. They were just kind of, not time limited, or they weren't very specific on who the information could be released to. But I think for the most part, everyone's gotten this tightened up. But, it's never a bad idea to just put your eyeballs on those and check them again. And that is all I have. I'll turn it back over to Jeremiah.
Awesome. Thank you, Susan. So let me look through our questions here. There was a really good question about the 20% rule. And again, if specific questions linger, it's probably easiest to go over it with your program manager. I think this afternoon, our fiscal team will speak to it a little more, and it may be helpful when they actually display a full budget and walk through it. I think that's part of their presentation. But I'm going to do my best, right, without that visual aid. And so if you go to the budget of your grant, you've effectively got 2 pages for each fiscal year. One is the summary page that's got like just the individual line items in a block totaled up, and then the next page is the summary page where it will have kind of the individual line items and then the details basically under there. And so my example would be on your summary page, you might have a salary line item that is $50,000, right? And so then you flip to your details page and it's got $50,000 and then maybe 2 or 3 positions under that are allocated either partially or in full to the grant, right? When we're talking about the 20% rule, we're talking about moving funding out of the supply line. So on your first page, the total of all the details to another line, adjustments within the details. And so for those 2 or 3 positions that are within the salary line on there, that is not falling within the 20% rule. And we typically understand that the details provided there are estimates. So obviously you can't go over what your salary line in total was allocated, but the way that the individual breakdown is detailed under there in terms of what position has too much, we're never tracking that to the dollar. We understand that, based upon historic salary and benefits, that's your estimate for the position. But sometimes a position is open for a time, or sometimes a position that exists fills in for another piece of the program for a time. And so movements of money within those details does not carry that 20% prohibition, right? Now, I think what I would add in terms of like helping us out and making sure that there's no questions in the future is that if you're gonna like create or remove positions in whole, so like substantially alter the details, that is something that you would need to reach out to us on. But moving some money from like one position to another within the details, that doesn't follow any 20% rule, and that is something that your agency is empowered to do as long as it's going to the positions that are already detailed on there. Similarly, you know, there can be some flexibility depending upon how you've outlined like your specific supplies between lines there. Definitely get in contact and work with your program manager, but like typical like business need movements within those details that are within the line item, those are much more flexible and don't require like don't have that contracted 20% requirement. And so that's we can typically do movements there pretty easy. We can even add or delete like positions where appropriate with permission without having to enact a full amendment. And typically how we would handle that is that if you eliminated a position in full or added a position in full, we can have an agreement really via email that will persist for a while, and then the next time we do an amendment to your contract that's a required amendment due to a term date change, due to a substantial alteration in scope, etc., when we open the contract up, then we would want to make sure that the budget aligns. And so we have some flexibility there. It's hard for me to adequately describe like everything that's like a required approval process versus what we're pretty flexible on, but your program manager can absolutely walk you through that. So as you have situations pop up, reach out to them. They can provide you with technical assistance, kind of let you know where we fall on certain aspects, and then once you kind of get it and get into the role, you will find, I think, that we have a pretty good amount of flexibility within those detail lines. Let's see what else we've got on here. Who needs to be present during monitoring? It looks like Susan French has responded. So the question is, who needs to be present during monitoring, site visit, i.e. program director, financial director, authorized official? For program monitoring, definitely the project director and executive director normally, and any staff paid under the grant. Authorized official is not required to attend. However, sometimes in smaller agencies, they pop into the entrance conference to say hello, but there is no requirement for attendance. Susan's absolutely correct, right? So, an example that I would use is if we go to like Metro Nashville government and are monitoring one of their programs, like we in no way anticipate that the mayor of Nashville is going to be present in our entrance conference, but we would want the project director to be present and the fiscal director, and the individual like staff on a grant aren't required in the entrance or exit conference, but we do conduct staff interviews, as Susan just went over a minute ago. So they may not be present in that entrance conference, but we will have scheduled times with them through you in order to have interview times for the staff. And so I think the key person is really the project director, at least for the program monitoring entrance conference. The fiscal director can sometimes be very helpful, but for the fiscal monitoring, it's probably almost the reverse, right? Where they're really wanting the fiscal director to be the absolute one that has to be there. And then having the project director can also be really nice to be able to speak to project expenditures. But the authorized official is never required, but they're welcome to attend. And sometimes in smaller communities, they often do. And I'll pause here to see if anyone has any last minute questions. And so with no last minute questions in the chat, I'm dropping in the direct link to our attendance form again. If you have not signed up on this today, please click on this link now, go in and sign up. Again, you only have to do this one time throughout the course of the day. That includes this afternoon. So if you've already done it, you're taken care of, but there is a link in the chat now directly for individuals if you want to go in and do that. We have ended early, so we have met our goal of trying to be timely. And the next session with fiscal begins at 1:30 Central Time and is scheduled to go 1:30 to 3. So quite a bit shorter than today's session. We'll probably have an even bigger audience with the fiscal directors joining, but we look forward to seeing everyone then. And just remember, the fiscal conference link is a separate meeting appointment. In the email that I sent out, there should have been two. So just make sure on your calendar you're clicking into the new meeting and not this one. There's also a link on the agenda that you can click on, but it is a separate meeting and will wind up being a separate recording. Thanks everyone for their patience and understanding today and for their attendance. If you have any questions, reach out to us. I hope y'all have a great day and a good weekend. Thank you.
Thanks, Jeremiah. Thank you all.
Thank you.